Third-party complaint. A third-party complaint is a claim that a defending party may, with leave of court, file against a person not a party to the action for contribution, indemnity, subrogation, or any other relief in respect of his opponent's claim. There could also be a fourth, fifth, sixth, or etc. party complaint with the same purpose and function. Leave of court to file a third-party complaint may be obtained by motion under Rule 15. Summons on third, fourth, fifth, or etc. party defendant must be served for the court to obtain jurisdiction over his person since he is not an original party. So what are the claims that may be contained in a third-party complaint? It can be for contribution, indemnity, subrogation, or any other relief. A prerequisite to the exercise of the right is that some substantive basis for a third-party claim be found to exist, whether the basis be one of indemnity, subrogation, contribution, or other substantive right. The bringing of a third-party defendant is proper if he would be liable to the plaintiff or to the defendant or both for all or part of the plaintiff's claim against the original defendant, although the third-party defendant's liability arises out of another transaction. The defendant may plead another as third-party defendant on allegation of liability of the latter to the defendant for contribution, indemnity, subrogation, or any other relief, or on the ground of direct liability of the third-party defendant to the plaintiff, or the liability of the third-party defendant to both the plaintiff and the defendant. There must be a causal connection between the claim of the plaintiff in his complaint and a claim for contribution, indemnity, or other relief of the defendant against the third-party defendant. The third-party complaint does not have to show with certainty that there will be recovery against the third-party defendant, and it is sufficient that pleadings show possibility of recovery. In determining the sufficiency of the third-party complaint, the allegations in the original complaint and the third-party complaint must be examined. A third-party complaint must allege facts which prima facie show that the defendant is entitled to contribution, indemnity, subrogation, or other relief from the third-party defendant. It bears stressing that common liability is the very essence for contribution. Contribution is a payment made by each or by any of several having a common liability of his share in the damage suffered or in the money necessarily paid by one of the parties in behalf of the other or others. The rule on common liability is fundamental in the action for contribution. The test to determine whether the claim for indemnity in a third-party complaint is whether it arises out of the same transaction on which the plaintiff's claim is based, or the third-party plaintiff's claim, although arising out of another or different contract or transaction, is connected with the plaintiff's claim. Now, what is the test, or what are the tests to determine whether the third-party complaint is in respect of plaintiff's claim? As early as Capayas v. Court of First Instance of Albay, the Supreme Court already outlined the tests to determine whether the claim for indemnity in a third-party claim is in respect of plaintiff's claim. These tests are: first, whether it arises out of the same transaction on which the plaintiff's claim is based, or whether the third party's claim, although arising out of another or different contract or transaction, is connected with the plaintiff's claim. Second, whether the third-party defendant would be liable to the plaintiff or to the defendant for all or part of the plaintiff's claim against the original defendant, although the third-party defendant's liability arises out of another transaction. Or third, whether the third-party defendant may assert any defense which the third-party plaintiff has or may have against the plaintiff's claim. Okay, let us illustrate. The plaintiff files a complaint against the defendant, and then the defendant files an answer with a counterclaim. Maybe there is a cross-claim against the co-parties like the defendant 1 and the defendant 2. Now, where does the third-party complaint come in? Okay, so the defendant or the defendants may file a third-party complaint against the third-party defendant. A third-party complaint is a procedural device whereby a third party who is neither a party nor privy to the act or deed complained of by the plaintiff may be brought into the case with leave of court by the defendant who acts as a third-party plaintiff to enforce against such third-party defendant a right for contribution, indemnity, subrogation, or any other relief in respect of the plaintiff's claim. The third-party complaint is actually independent of, separate, and distinct from the plaintiff's complaint, such that, were it not for this provision of the rules of court, it would have to be filed separately from the original complaint by the defendant against the third party. It is one thing to say that a third-party defendant may be held liable to indemnify or reimburse the third-party plaintiff in respect of plaintiff's claim, but it is quite another to state that a third-party defendant may be held liable to a third-party plaintiff. The second instance may not carry with it the necessary connection to the main cause of action, and therefore is not allowed by the rules, for it introduces a controversy that is entirely foreign to and distinct from the main cause. The first instance is allowable and should be allowed if it will help in clarifying in a single proceeding the multifarious issues involved arising from a single transaction. Now, what is the purpose of a third-party complaint or allowing the filing of a third-party complaint? The purpose of Section 11, Rule 6 of the Rules of Court is to permit a defendant to assert an independent claim against a third party which he otherwise would assert in another action, thus preventing multiplicity of suits. All the rights of the parties concerned would then be adjudicated in one proceeding. This is a rule of procedure and does not create a substantial right. Neither does it abridge, enlarge, or nullify the substantial rights of any litigant. This right to file a third-party complaint against a third party rests in the discretion of the trial court. The third-party complaint is actually independent of, separate, and distinct from the plaintiff's complaint, such that were it not for the rule, to repeat, it would have to be filed separately from the original complaint. Since it lies in the discretion of the court, there is a requirement for a leave of court.